Good afternoon, everyone. My name is Marinus Nederlof. I am the in-house mediator for the judiciary. So basically, I do mediations full-time at this stage. I've been asked to just quickly run you through the mediation process. So I've specifically looked at the relevant aspects that if you are able to act as a judge, that you know what's expected of you in terms of the court process. So yes, let's just have a look-see. There we go. Okay, there's a quick overview of what we're going to be looking at. Okay, the first thing, court-accredited mediators. The only type of mediations that's relevant for the court is court-accredited mediations. So that means the mediator will always be court-accredited. It can be in the form of a court-connected mediation, in which case the court will refer the matter to mediation in terms of the process, and we'll get to that later. Or it can also be in terms of a private court-accredited mediation, which means that the parties decide to have a specific mediator that's not available in a slot that's on our diary. So they decide to approach the mediator personally and arrange for the mediation. The same benefits will apply, but we'll also get to the benefits. Mediation types, as I've explained there, you can see that we have the court-connected mediation and the court-accredited private mediations. Both of them are court-accredited mediation. And that's just another, that indicates to you that in terms of the court-accredited ADR, there's a stay of proceedings in terms of Rule 38.3, and that is for court-accredited private mediation as well as court-connected mediation. Any other form of ADR, whether it be mediation or if the mediator is not a court-accredited mediator, the proceedings will not be stayed in terms of the rules of court. Okay, so where do you find the procedure? The rules of court, specifically Rule 38 and Rule 39. Rule 38 has to do specifically with the referral procedure, so that would be the most important for you guys to have a look at. Rule 39 is more to do with the obligations of the parties, who must attend the mediation, how the mediation brief should be completed, and the like. So that's not that important for as far as you are concerned. You will not have anything to do with the mediation process. You will only, of course, need to refer the matter to mediation at the correct time. Then also practice direction 19, which is actually important in the sense that it gives a list of the 9 matters that has to be referred to mediation. So in terms of practice directive 19 sub 5, it says the following matters are compulsory, and those are matters that dealing with insurance claims, medical negligence, professional negligence against legal practitioners, building contract claims, divorce, custody of and access to minor children, spousal and child maintenance, loan default claims, motor vehicle accident claims, and defamation claims. Then we also have the Registrar's notes. The Registrar's notes is basically just a few additional aspects in respect of mediations that's more clearly set out in the Registrar's notes. Okay, where do mediations fit in? Now, this is an interesting topic. Generally, we accept that the matters are referred to mediation after the exchange of pleadings has been dealt with. So technically, it would be after the discovery phase, more specifically. But the judge always has a discretion to refer a matter at a sooner stage, should the judge feel the need or think it might be necessary to refer the matter sooner. Cases like where, for example, it's an insurance claim or something to that effect, and there's a very small claim amount. It's barely made the minimum requirement for a high court matter. If that matter is sent through the entire process and pleadings are closed, I've dealt with many matters where you get to the situation by the time they get to the mediation phase, the claim amount is $30,000, but each party has already expended around $50,000 in legal fees. So by that time, nobody really cares about what the actual merits of the matter is. They just basically want to finalize the matter so that every party can get a cost order at the end of the day. which of course is very counterproductive for the mediation process. So that is something that a judge would be, it would be in the judge's discretion to decide to refer the matter sooner in that case. Okay. And then we just have Rule 38, a bit more extensive on that. So that's basically everything we've dealt with, so you can just have a look at that. Then we get to the mediation process. Now, I've not gone into too much detail as far as the process is concerned, mostly just so you know at what stage the matter will be referred and when it will be back in court. But step one is basically the initial mediation referral order. So in terms of that, that is in the Registrar Notes 3 sub 3 and the practice directions in the Registrar's Notes 3 sub 4 to 6. At this stage, you will see if the matter is a private court accredited mediation or a court connected mediation. At both of those will be referred in terms of a court order. And then it's also important to note that the initial referral order will already indicate the parties that will, the practitioners who will accompany the parties, and if an interpreter is required, and then also the next date for the formal mediation referral to be issued. And it's important that this process doesn't take any longer than 2 weeks. So typically the parties would request for the matter to be sent to mediation, or you would decide that the matter should be referred to mediation in terms of the practice directives, and postpone the matter for 2 weeks in order for the parties to come to the ADR office and to obtain dates, and then to basically request the court to refer it to mediation. What the practitioners would need to do during that time, they would need to arrange amongst themselves to meet each other at the ADR office, to have a look at the diary to see what mediators are available, select the mediator, and then I've actually added the mediation reservation sheet to the back as an example for you, to obtain that, and then to prepare the draft mediation referral order, which will be uploaded, and that will ultimately be issued by the judge. But yes, that is what the 2 weeks postponement is for. Okay, well, basically, if it's, as long as a court accredited mediator, there's a specific list of court accredited mediators that's also available on the website. As long as a court accredited mediator is mediating the matter, then it's a court connected mediation. And then it will go through the process. The court will give you the stay in terms of the rules of court. So there will be basically a 2-month stay, or until the mediation process has been dealt with and finalized. No other pleadings will be exchanged, and no process will continue in the court until the mediation has been finalized. If you elect to use any other mediator, anybody in this room, for example, that's not a mediator, then it's a private mediation. The parties can elect to obviously utilize any form of ADR they want to, but then they will not have the benefit of the court staying the proceedings in the meantime.
If you'll allow me, just to again look at the difference between these two. Your ordinary mediation is you decide we want to try and mediate this. It's old-time settlement negotiations. If you want to make use of a mediator, you do so. Who's going to pay for the mediator? You. When will you do it? You decide. Where will you do it? You decide. But it's not going to be at the court, and you're not going to get any of the privileges which you will get if it is court accredited. What are the privileges? Time out. You don't need to exchange pleadings. You don't need to come to court. It's a 2-month time out period that the court gives you in order to attempt to settle it. If you want that, you must go for court accredited mediation. And there are 2 types of court accredited mediation. One is what we call the court connected mediation, and the other one is court accredited private mediation. What is the difference between these two? Only one thing. For court connected, who pays the mediator for his or her time? The Office of the Judiciary, the court. us. If it is court accredited private, who pays the mediator? The parties. For the rest, on those two, everything is exactly the same. You must be a court accredited mediator. If you want the 2-month time-out period, you go for court accredited mediation. You see the difference and the similarities? So it's just who pays what. I still saw a frown on your face after this 2-week thing. There's many judges who do not actually give an initial referral order. It is fine as long as the parties amongst themselves, prior to whatever is going to happen in court, attended to the mediation office in order to select the mediator of their choice, and that is the big success of our mediations. They can select their own mediator. They've booked a date, and they got something from the mediation office to say, we confirm you've booked this. But we do not really want to do that because many parties go and they book it, but they never have that maiden order of court. Now they are depriving somebody else from the opportunity of making use of one of our top mediators at a specific time slot. So that's why we have the initial referral, where they either ask the judge to refer this for mediation, or the judge out of his own initiative decides it must be referred. Then the judge makes an initial referral order. And the only thing that order says is, go and get a date. Go and book a mediation. With that order in the hand, they will go to the mediation office and they will book it. They get proof that they've done it. And so the next appearance, which should not be later than 2 weeks, it can be earlier, but not later than 2 weeks after the initial referral, the court will then take that information and proceed with the procedure to make the referral order. And from the moment the referral order is made, you've got timeout. 2 months timeout. DAs do not run against them for the exchange of pleadings during that period.
For example, if by that time there's something in terms of a case plan that the parties were supposed to file something within 5 days, but the matter is at that stage referred to mediation. If there's 3 days left, then there's a 2-month period that will run. After the 2-month period only will the last 3 days run out. Or technically, or if the mediation finalizes sooner, then the parties will still have another 3 days to file the next step in terms of the case plan. Now, technically, the registrar is now slightly corrupting you before you are even judges, because technically speaking, I do require an initial referral order before I'm allowed to allocate a date. Now, some of the judges are a bit problematic in that sense, and they decide to do exactly what the registrar just indicated. But I think I'll ask all of you that if you ever get the opportunity to act, that please just issue the initial mediation order. It makes my work a lot easier, my officers' work a lot easier. So yes, so that's basically what I said in this slide as well. And yeah, if the mediation, if there's certain errors on the initial mediation order, then that will mean that we will have to go back to the judge and ask for the order to be amended or to be corrected. And that, of course, was a waste of time and resources. Okay, so now we get to private court-connected mediation. I think we've more or less covered this, but this slide will indicate exactly the similarities between court-accredited private mediation and court-connected mediation. The one other benefit of court-accredited private mediation is that not all the parties need to be represented. If you have a situation where one of the parties are acting for themselves, but they still want the opportunity to go to a mediation and to make use of a mediator, then they would be allowed to go to private mediation. But in terms of court-connected mediation, both the parties need to be represented by legal practitioners, and the legal practitioners need to be present at the mediation. Okay, and then step 2, with the parties would then identify the mediator and obtain mediation dates. I've indicated the rules and the registrar's notes that you need to look at there. And then it's just a quick, again, the difference between the court connected and the court accredited, which you've already covered. Okay, then if the parties, for some reason, and I've never really had a situation with this, but if it happens that the parties go to the mediation office and for some reason they can't decide on a specific mediator, or there's not a slot available that suits the practitioner's diary, whatever the case may be, the ADR office will issue them with a notice giving them the three available open slots with 3 different mediators, and when the parties go back to court they will give the judge that note, and the judge will decide what time slot and what mediator will be used for the mediation. I don't know if you are aware of one single, I don't think we try to steer away from that. I think the judges as well, they try to accommodate the parties as far as possible. Of course, we have a much better result if the parties get to choose what mediator they want, and of course a time slot that suits all the parties.
On this point, I might just mention that at some stage, about 1-2 years ago, a legal practitioner is a very clever person. They always find loopholes. So what they did was, when they were under pressure in their own practices, they used mediation in order to get time out. Yes. And it's so easy to do it. And then the judges realized what was going on, so they wouldn't tolerate it. So the next thing they did was, no, there were no available dates. It's only these inexperienced mediators. And Judge, this is really a complex issue. So one of our judges said, really? So he took up the telephone and he said, bring that diary here. And he just selected on their behalf. So that was the closest we came to this scenario. It happened in 2 case management sessions. End of story. Never happened again.
Then the next step is the mediation referral order. Okay, so in terms of that, once the parties have obtained the dates and they've decided when they will file their briefs and if a court interpreter will be necessary or not, the practitioners, usually the plaintiff, will prepare and upload a draft order for the court's consideration. So normally you would just look at that and see if you agree with everything. That would be the order that you would issue. Usually the ADR office would also indicate the next date for the status hearing, but I've since removed that because obviously it's the judge is in a better position to say what the next available date would be for the court. I've noticed that seldomly was used anyway, so so that would be the one thing that the judge would have to decide themselves. Then we get to the stay of the process. So in terms of Rule 38.3, it means the process is stayed. No litigation proceedings may take place from the moment and the point of the referral order is issued until the managing judge makes the order at the next status hearing, which would mean that the litigation would either proceed or that the matter has become settled and the settlement agreement is made in order of court. Very important for referral orders from your side, it's crucial that you indicate the correct mediator. Because I need, when I'm processing for the payments for the mediators, I need to attach that court order to the payment request. So if the mediator is not indicated correctly, then I need to contact the judge or the judge's clerk, and we need to have the court order corrected or varied, and that's of course a duplication of work. And then we get to the mediation briefs. The only reason why I worked this into the presentation is just so you can take cognizance of that. It might be at some stage that one of the, there's a certain limitation to what the mediators are allowed to put in their reports. Normally, it would be a one-liner and they would say the mediation was successful, the mediation failed. But sometimes one of the parties were obstructive, or there's some other reason that the mediation couldn't proceed. One of the parties might not have had settlement authority, or the briefs weren't properly exchanged or comprehensive enough, or there might be certain things that the practitioners or the mediator would give through to the court, and the court would then consider that if perhaps a cost order should be considered in terms of the mediation process that then failed. So the mediation briefs, that's also important in respect of the mediation briefs, is that it should not be uploaded on the e-justice system. We've had a few situations where practitioners did upload it. At no circumstances are the judges allowed to look at those mediation briefs. It is deemed to be confidential. The entire mediation file, it's still a paper process, and the entire file with the entire contents of the file remains confidential, and it's kept by the mediation office afterwards. At this stage, we've kept all of them. I don't know how long we'll keep them at the end of the day, but yes, it's not for the judge to have insight into it, or for the parties to use it at any stage, at any other forum, or during any other proceedings. Okay, this is basically just a few in terms of the registrar's notes, the requirements in terms of the mediation briefs. There's just a quick set out of the plaintiff files their briefs, the defendant files their briefs. Everything is delivered to the ADR office. The ADR office will make sure that the mediator is supplied with the mediation file in time for the mediation to prepare. The parties will then make sure that their clients have had a look at both the mediation briefs, their own brief being the one that they would have given instructions for in any event, and then the parties will attend the mediation to discuss the options further. And then, of course, we get to the mediation session. A mediation agreement is required if it's court-accredited private mediation. Otherwise, the basic relevant portion of the mediation agreement is already incorporated in the mediation referral order. Okay, then of course we have Rule 39.3 is the confidentiality issue. As I've stated before, if at any stage the mediation briefs comes under the judge's attention, the judge is not allowed to look at the mediation brief or to consider it at all. And then once again, the discussions during the mediations can never be used at any other forum. The only exception to that, I'm not sure, I believe there might be one or two other exceptions. It's child abuse. If there's any averments, and if one of the parties has immediate bodily harm, isn't that also one?
Yeah, it's not.
Okay,
the rules pertaining to confidentiality and mediation are actually internationally accepted. It's basically only on child abuse. Even with I know some people, we had a case where there was an issue about immediate bodily harm, which was imminent. But strictly speaking, even that should not be brought to the attention of the
No, that's in terms of the parties themselves. Let's say you've got a divorce matter,
but where it's children,
you
must reveal it to the judge, because the judge must immediately take steps in order to perhaps appoint a social worker. So
and in that case, the mediator will, if there's any averments in respect of child abuse, the mediation will immediately be stopped and the report filed as soon as possible, and the ADR office will then make sure that the judge is immediately informed, and the necessary steps will be taken after that. But that would basically put an end to the mediation proceedings in any event. Okay, the mediation cost, that's something the registrar touched on earlier. Of course, the obvious benefit of having court-connected mediation is that the judiciary supplies the mediator and pays for the mediator. And with private mediation, the parties would have to arrange for them with the mediator for the mediator's fee and to pay the fee between the parties. If you at any stage have to award a cost order, the cost in terms of mediation would then be, in terms of a private mediation, would be the mediator's fee, and then also counsel's fee for time spent attending the mediation. That would also be for preparing the briefs and for consulting with the client to take instructions for the brief and to discuss the other party's brief with your client. Mediation report, that's normally, like I said, it should technically be a one-liner. It should basically only indicate if the matter has become settled or if the matter has not become settled, with the exception of the one or two things that we've discussed. Like I've indicated before, the mediator is under certain circumstances, allowed to make to elaborate slightly if it's necessary in terms on the report. The recommendations I do sometimes see that a mediator will make a report to say that he recommends that a second session be done in a month's time when whatever they're waiting for a report from an expert or whatever the case may be. Technically speaking, the mediator can't make any recommendations to the court. The court would have to decide if they would want to consider that. The parties can also raise that issue in court, so it's not necessary for the mediator to raise it. And the court will then technically decide to refer the matter to mediation again at a later stage. But if the mediation cannot proceed for let's say for 6 months, because we need to wait for an expert report in terms of custody and control, then the court will have to make a specific order for that to happen. The mediator can't recommend that the proceedings be stayed for 6 months in order to wait for the report.
Just on that issue, I think when the rules initially was written, we should not have used the word recommendations, in all honesty. It's something which often happens, but one wouldn't want to call it a recommendation. In fact, it happened last Friday again, is that the mediator will pitch at the mediation as per court order, and there's nobody. And later on they start calling the practitioners. Where are you? You booked a mediation. There's a court order saying that you must attend this mediation. Oh no, I've spoken to my colleague. You see, I actually went to Swakop for the weekend and I realized I wouldn't be able to make it. We'll get another mediation date. Now there's a mediator who offered his time. He came. We're going to pay him with state funds. And it's contempt of the court order, because the court order says you must be there. So what the mediator then will do, it was discussed last Friday evening, it was brought to my attention, it happened last Friday again. So he will say, the mediation failed. Why? None of the parties pitched for this mediation. So that none of the parties came for the mediation, or one of the parties didn't come, but the plaintiff was here. He was ready to proceed, but defendant didn't come. He simply states it, and the court can then take that into consideration to say to that party, the defendant who didn't come, you know what? You are going to pay the loss of the government for paying that mediator, because it's due to you that this mediation failed.
Yes, and then of course you can also have a look at the situation, and if it seems that the parties simply didn't pitch at the mediation, or one of the parties didn't pitch because it might be that they want to just prolong the timeline within the mediation will be finalized, then that would also be a reason for the court to say, no, okay, you've had your opportunity to mediate, you elected not to mediate, so the court is not going to entertain the mediation process any further. We'll finalize the pleadings. If you want to mediate, do it on your own time during a private session. Okay, well then of course you are not obliged to follow the recommendations made. Typical deviations that the court might have from the order or from the mediation report is, for example, if a settlement agreement has been attached to the sides, but the settlement agreement isn't really good in law, it's against the law for that matter, then certain amendments can of course be made to that. And then once again, request for unreasonable extension of time for the purpose of mediation. And yes, that's the type of things that probably will come up. Then after the entire proceeding, you will have a status hearing. That would normally be indicated on the mediation referral order. The court will decide what the next convenient date is, and that's the date on which the parties will give feedback in respect of the mediation. So the court will take note of the outcome of the mediation, and that shouldn't be more than 2 months after as far as possible. If it doesn't suit the court's diary, then it might be slightly longer than that. But 2 months is basically the timeline that is allowed by the rules of court. So you should make every attempt to keep it within those time frames. there's two aspects, of course, as I've explained earlier. If it's private mediation, the parties will pay for. Yes, okay. But then in terms of what cost orders will be made, if the court has to make a ruling on what parties should pay costs, let's say one of the parties didn't pitch for the mediation, and the court decides that a cost order should be awarded against the party not attending the mediation. That will be depending on the type of mediation. If it's court connected, then there is no cost for the mediator, unless you decide that, listen, you've wasted government funds. So I think typically what would happen in a situation like that, I don't know if we've had such an order yet, but I think after Friday we might have one.
No, we have a couple. Judge Westhuizen actually started him and Judge Kaya.
Okay, good. But then it would normally be an order against the legal practitioner who didn't come to the mediation, and it would actually be a de bonus cost order for that practitioner to pay for the mediator's fee. If there was a private mediation, then of course the cost that would be considered would always be the cost of the mediator as well, because the parties would pay, would share the cost of the mediator, or whatever the arrangement between them would be. But yes, if it's a court-connected mediation, then typically there wouldn't be any cost for the parties in terms of the mediator's fee. It will only be for the parties, the preparation for the mediation, the preparation of the briefs, consultation with client in respect specifically for the mediation, and then attending the mediation proceedings. If one of the practitioners came to the mediation, the other one did not, that might be an hour fee that the practitioner is going to charge his client for. That was unnecessary, so it's wasted cost.
Usually, the courts do not make separate orders pertaining to costs and mediation. Costs follow the suit. And any cost incurred during the mediation process, if it was court-accredited mediation, follows the procedure. So what are these costs? It is the time spent by the representative legal practitioner representing those parties in preparing the mediation briefs, filing the briefs, and attending the mediation. Because we do not allow parties to appear during a mediation without being legally represented. But that is ordinary cost in the litigation procedure. The cost, or rather the expenses pertaining to the payment of the mediator, there is no expenses if it's court connected. But if it was a private one, then the parties will also agree amongst themselves, let's split the fee. And that private court accredited mediation, that mediator does not need to follow the same fee structure that the court pays them if they attend to a court connected one. What they usually do is they ask for an hourly rate. So if they work at an hourly rate of 1,400 Namibian dollars per hour, and the mediation took that mediator plus his preparation time, maybe 3 hours, then he will charge them 3 times that, and usually the parties would split that cost. The punitive cost orders that you will get in a mediation is that the judge, for instance, will say, because there was some obstructive behavior from this party, you're going to refund the government for the money that we paid that mediator. But that's more a punitive thing. And they will usually, the orders that I've seen, did not include the time of the legal practitioners. Usually the judges will leave that aspect to the cost follows suit type of cost order. But simply that payment. And at the moment we pay them
4,206
per mediation to a maximum of 2 sessions. But remember, it's professional people who take a whole morning or a whole afternoon out of their court or out of their diaries. They prepare. If it is really complicated cases, building contracts, those type of things, they sometimes prepare for hours. And they sit there from 2 o'clock until
They have to be
7,
available
8,
for at
9
least 3
o'clock
hours.
until it is finished. Yeah, at least 3 hours. If they need to proceed to a second session, we only pay up to a second session. We've had mediations which went on to a third and a fourth session, but we only pay up to the end of the second session. For the rest, they do it for free. So we are simply trying to remunerate
them for the time spent in doing that. If you are a court-accredited mediator who is in the employ of the government, a judge or a magistrate, in other words, paid a salary by the government, then you do not get extra money. Which means that whenever I mediate during the daytime, whatever time I lost, I must make up in the evening in my office, and it's for my own account. So I do not get that additional benefit. Since, when did you start with us?
July.
He's been one of our first court-accredited mediators. He was in private practice. He had an excellent record, and he started in July as our full-time in-house mediator, also running our mediation section. Of course, he does not get paid to do these mediations because he gets a salary. He's supposed to do mediations. And of course, if he did the mediation and there was obstructive behavior, then there can't really be a punitive cost order because it didn't cost the government any money. Did that answer your question?
And I think in addition to the two of us, we have about 5 more court employees who are also accredited mediators.
In our directorate, but they are
In the main division.
But there are quite a number of other mediators who. Ben Meiberg, he's a court-accredited mediator.
I know he's retired now.
Yeah, well, he's retired, but he used to be a magistrate, and he was one. And he's still a court-accredited mediator. Rina Horn is still a court-accredited mediator. Eileen Raak is a court-accredited mediator. Patience Daringo. Veru from, who used to be at Legal Aid, he used to be, well, he's still a court-accredited. So we have quite a number of them. I can't now immediately think, oh, Johanna Salionga is a court-accredited, Elena Nandagu. I'm just mentioning some of the magistrates' names because I know that you know them, that they are all court-accredited mediators. In order to become a court-accredited mediator, you have to attend our custom-made mediation training. That's it. If you read the High Court Act, it provides that the Judge President can, in consultation with the President of the country, make rules. Then if you read the rules, the Judge President can make practice directions. If you read the practice directions, the Registrar can issue Registrar's notes. So, once again, go to the wonderful website called Superior Courts, High Court. What does it say? Legislation or something like that. I think legislation or something. Under that, you will get directions or directives.
Everything relevant to mediations is actually under the mediation tab. So if you go there and you go to legislation.
I'm not sure whether the registrar's notes are there.
It is.
Is it?
Yeah. It's the one.
Everything that we've referred to between me and Mr. Nederlof, you will find on our website.
And then, at the end of your notes, I've attached a copy of a mediation referral sheet. This is typically what the sheet would look like that's uploaded to the e-justice system after the parties reserve the date. So this is the document that you would have a look at to make sure that the court order that's been the draft order that's been uploaded corresponds with this sheet. Because this is what has been indicated or captured in the ADR office mediation diary.
What is of importance in the aspirant judges training also is, of course, the contents of your orders. The most important thing, on an initial referral order is go and get a date. You don't really need more than that. But on your referral order, very important, the identity of the mediator. When, where, and the exact time when the mediation will take place. Whether it is court-connected or court-accredited private mediation. The status hearing, which are called upon after the mediation. And remember now, from the date of the referral order up to that status hearing, not more than 2 months. So they must also make sure that they bring a date early enough so that they can actually do the mediation. If they need a second session and they need to postpone, that they can do that in a day or two time, a day or two, and for the mediator to compile his report and get it back to the court before the next status hearing. If an interpreter is required, the language. Why? Because we are going to also give them an interpreter. You know that in criminal proceedings, the government actually, or the state, gives the interpreters. In civil proceedings, the parties need to arrange their own interpreter and pay for them. It's not part and parcel of what you get for free by just paying those revenue stamps. But with mediation, we provide the interpreter. Now, the good thing about mediation, just a bit of background, I'm not sure whether any one of you really knows much about the mediation project that we've launched and how does mediation work. I'm sure all of you had ADR as a subject at university at some stage, so you at least know what mediation is. But the good thing about mediation is because it is so informal and so relaxed and 100% confidential. Not one single word what was said in that mediation is allowed to come to the presiding judge's knowledge. You're not allowed to use it in your pleadings. You're not allowed to use it in leading evidence or cross-examination. It's 100% confidential. But because of the informality of the whole proceeding, if your mediator is Ocherero, and both the parties are Ocherero, and they are represented by legal practitioners who at least speak and understand Ocherero, you don't need to do your mediation in English. There's no rule that says it must be done in English. Then you do it in Ocherero. And immediately the parties are at ease. There's no third party like an interpreter. But of course, if the one is Oshivambu and the other one is Ocherero and the other one is Afrikaans speaking like me, I need an interpreter. And then it will be conducted in English because that is our language. But if everybody speaks the same language, no objection in doing it in your own language. And that contributes towards the success of mediation also.
I can perhaps also just mention that the JP has given permission that we are also allowed to conduct mediations at the coast. So for the main division, it will either be at the SADC Tribunal building or at whatever arrangements was made at the coast with the mediator. Typically it would be at the mediator's office. If the parties are all from the coast, then they will use a mediator at the coast. Or they are allowed to if they want to.
We also have mediators who actually live and practice in Keetmanshoop. And they drive through, the two of them. They usually book for the same day their mediations, and then they drive through early in the morning, they come and do mediations, and tonight they drive back again. And I mean, these transport costs are all for their own pocket, but they enjoy it. And we've actually had it where both the parties lived in Keetmanshoop. They were all represented by legal practitioners there, and they would call us and say, listen, we are going to mediate here in Keetmans, we're not driving up. And it's wonderful for us. So we try to accommodate in as far as possible. In that case, I think that's it for today. Thank you for listening to us.
Thank you, everyone. En wat jou afsit hierso.
Ek maak mos die ding net toe.
O. Dit is baie sleg se hard drive, né?